I see we have the owner of the plaintiff's firm that brought the case. He can tell us all about this. You guys probably see him on TV a lot. He makes a lot of rounds. He was able to fit me in on this, so I appreciate it. But Neama, thank you so much for joining us. How are you?
Good, Megan. Thank you for having me. Glad
Yeah,
to be on. I know you have spent a lot of time in that courtroom, so I
yes.
appreciate all your efforts to cover the case.
Yeah, it was an interesting case for sure. Good verdict. I mean, I know you were hoping for more in punitive damages, but overall, what can you say about the verdict and this win for your firm?
Well, it's certainly a win when you have a defendant who's calling your client a lying, disgruntled ex. So, uh, the offer before trial was $100,000. So when you get a 4.25 plus $1 million verdict on an offer like that, that's fantastic. When you have your client vindicated and the jury says that she was sexually abused and she was physically assaulted and she didn't make all this up, that's certainly a win. Obviously, you can kind of look at the previous case that Kayla Myers brought, and that was the judgment in that case was approximately 10% of what we got. So, if you look at all those different factors, this was definitely a win for Jane Doe. Obviously, we want more. We always want more, but we'll certainly take this and a win. And we're going to move forward with the second Jane Doe lawsuit, which was actually consolidated with this case at the 11th hour. They filed a motion to severance. Judge Epstein granted it, but we were supposed to have two Jane Does in one lawsuit. But we'll get to have another trial, which I'm sure Megan's going to cover as well.
Yeah, I'll look forward to that. So you said their offer before trial was 100,000. Did you have an offer on your side? Was there a number that you were looking for them to offer to
Well,
settle?
we did. We made a offer to compromise in 998 in the 2 million range, and we between 2 and 3 million, we beat that as well. So,
Yeah.
because there was an offer to compromise that we beat by almost 2x, they're gonna have to pay for our costs, and then of course under California law, whenever there's a FIHA claim, sexual harassment, there's wage claims. We also get our attorney fees as well. So when you add all that up, the cost, the interest, prejudgment, the attorney fees, looking at potentially, $1, $2, $3 million on top of that judgment as well. So.
Now, you may have seen Soulja Boy's comments about how he's vowing to appeal, and I know you probably expect an appeal in this case, but can you talk about what you think the issues would be, and if there's any merit or possibility of something happening on appeal?
People can always appeal. That's their absolute right. I don't see any appellate issues. I mean, you were in court. I think the judge called it very, very fair. There was nothing that really came in terms of evidence that was improper from our perspective. Really, this is a case that came down to likability and credibility, which Megan, a lot of cases come down to, right? I mean, there's so many cases. You can say Johnny Depp won, as soon as he took the stand, and Amber Heard took the stand. ASAP Rocky case, right? The victim was not likable, not credible. We all knew watching what was going to happen in both of those cases, right? One civil, one criminal. And in this case, you have the Soulja Boy in court was very different from the Soulja Boy in deposition, right? That's why folks that are watching, if you're lawyers, you can learn a thing or two, videotape those depositions in important cases, because you can really use that at trial. And I think he was really impeached in terms of wearing fake glasses, taking the acting lessons. I don't think that the jurors really found him credible. And when you have a Jane Doe was telling a very personal story and being vulnerable about how she was physically and sexually abused. She's crying on the witness stand. She's crying when doctors and mental health professionals, and even during my colleague Ron Zambrano's closing argument, where he's talking about how she's beaten, punched, kicked, cut. I think that's what the jurors saw, and I think that's why they returned the verdict that they did.
But it seems like the corroborating evidence that they had, like the text messages, at least from the discussion, the limited discussions I had with the jurors, it seemed like that played a role there in corroborating her testimony, making it like more than just a popularity contest, but they thought that there was actual evidence supporting her case. I mean, do you guys look for stuff like that when you're interviewing possible clients and trying to decide whether to file a lawsuit? I mean, you
I,
need
I
more
do.
than testimony.
Of course, because like you said, if it's just a he said, she said type situation, oftentimes that's very difficult for jurors to side with the plaintiff, even though the jury instruction says that if you believe the testimony of the victim or any witness for that matter, you can determine that that fact was proven. But there are a lot of jurors out there that won't believe just the testimony of the victim. So obviously, you've covered a lot of cases. We sue a lot of celebrities, and jurors love celebrities. So if someone is coming to our office, and we've sued Kanye, Lizzo, Jason Derulo, Takeoff, Megan Thee Stallion. I mean, you've covered all these cases, not just the Soulja Boy cases. What I ask, obviously, I get the client's story, but there's two things that I spend time talking to clients about. What corroborating evidence do you have? Did you tell law enforcement? Did you tell a doctor? Did you even tell a friend or family member? And this is why. Even though the conversations with loved ones might be hearsay under the rules of evidence, if the defense argues that this is all fabricated, those prior consistent statements can come in under the rules of evidence. So I always ask, is there anything I can corroborate what you're saying? Not to say I don't believe you, but it's not what I know as a lawyer, it's what I can prove. So I spend time talking to the client about that corroborating evidence. In this particular case, we had a treasure trove of text message evidence, right? We had the pictures of the bruising. And I don't think the defense had a good explanation for all that. So that's one. The second thing I do, Meghann, is I prepare them for the very real possibility that their case will go all the way to trial, because they'll be called a liar. They'll be called a jealous ex. They'll, the defense and even people that are watching on social media, they'll say this is all about money. This is a shakedown. This is extortion. So I ask them honestly, are you willing to take this case the whole way? Because if you're not, these aren't the types of cases that are going to settle with a demand letter. It's not a car accident or a slip and fall. So I prepare clients for that possibility, because if you're not willing to go the whole way in a case like this, then there's a very good chance that the defense will play that game of chicken, push the case up to the brink of trial, hoping that you'll drop it or you won't show up.
In terms of likability of who's testifying, and I mean, I think it's clear that obviously the jury preferred the woman's testimony, and one of the female juror I talked to said that they thought Soulja Boy was lying on the stand about a few things, but then there was the older man who seemed to at least credit him a little bit with mitigating the huge damages. He said the idea that there was a debate in the jury room about whether she was really a true victim or whether she was part of this entourage lifestyle. So is that a credit to his testimony at all, or is that just part of the case? There's kind of the facts of the case, because your colleagues did a good job of basically just acknowledging that this wasn't just a clear-cut case, that she had acknowledged some of the things that she had done too, but that there was no accountability from him.
I think you have to, so when we went into the trial and even during our jury selection, we made it clear that this is a victim, but she chose to stay with her abuser. And some folks, especially people that, don't understand the psychology of abuse, sometimes maybe older jurors, they say, well, you're being abused. If you're being beaten and raped, why do you choose to stay with him? Why do you send messages to him saying that you love him? So that's why I think it was important to talk to the jurors about that very real fact, potentially negative fact that could have hurt us. So I think, like you said, the reality is jurors love celebrities, and especially in LA County. So when you take a case against a celebrity, you have to know that the deck may be stacked against you, and people may have some preconceived notions about how victims should act. And when they don't leave, they don't report right away. And look, I dealt with this all the time, not just as a plaintiff's lawyer now, but I was a prosecutor for many, many years. I prosecuted domestic violence cases. I know the psychology of abuse and how victims, oftentimes they don't leave, they return to their abusive partner. So this is something I think it was important to front for the jury. And like you said, Meghann, I think the problem with the defense is they took no accountability for anything. They denied everything. None of
Mhm.
this ever happened. We don't know where the bruising came from. When I said I hate you, I hope you die, and I'm threatening your family, I didn't mean any of that. Well, that's not reasonable. So, I mean, jurors, they're not stupid, and I think they realized that when they went into that deliberation room.
So where are you at with the other case, the one that got severed? Do you have any kind of timeline on a trial date on that? I think we talked about that, but for the
Well, we're
benefit.
hoping to go to trial as quickly as possible. Obviously, we're hoping that the cases would be tried together because it would be a much stronger case when there's two victims telling the same story of physical and sexual violence. The
Mhm.
defense filed that severance motion. It was granted. Now, I understand why the judge granted it. It would have been an appellate issue, right? Which we avoided now. But now there's going to be a whole nother jury that's going to have to hear a whole nother case of very similar abuse allegations. But look, maybe Soulja Boy's learned his lesson, and maybe he's gonna make a real offer in the seven figures, and our client's gonna have to consider it. But if it's gonna be another, lowball $100,000 offer, I can tell you right now, just like I would tell his lawyers, that's a non-starter, not something we're gonna consider.
Yeah, yeah. So you have, I mean, we were talking yesterday that you hope this is a wake up call to the industry, that you have, and you have other employment related cases like this that are, I mean, really unusual and kind of outside the box employment cases in terms of wage losses and that kind of thing, just because of celebrities and the agreements that they have. Can you talk about the Lizzo case and where we're at with that? I know that was what most of that was dismissed under anti-SLAPP, but that's under appeal, and you seem pretty confident that you're going to have some success at the appellate court.
I think so. I think some of it was dismissed, but I think our core claims are still there. Lizzo's basically the entity is still there as well. So even if she's out, the entity is going to be responsible. So I feel confident about the case. It happens to be before the same judge. So we like Judge Epstein, and he also happens to have the Jay-Z extortion case. I don't know if he's the musician judge in LA County. It's good luck or bad luck, but I think he is a very fair judge. I like his temperament. I like being in his courtroom. So we're excited to present the Lizzo case. And one thing about us is we're sort of unique in that we're a personal injury and employment firm. So you saw in this Jane Doe case, we had employment claims with our best employment lawyer, Ron Zambrano, there, but we also my partner, Dina Inechi, who's a personal injury lawyer. And we'll take these cases, these crossover cases, because we have the capability to handle them. And I do think we are seeing a bit of a change. The music industry has been late to the game, but you and I talked after this verdict. And obviously, Diddy is by far the biggest and most serious of the musician cases. But look, there's a lot of others. We've talked about all these different musicians who we believe take advantage of people around them, whether it's members of their entourage, their employees, their intimate partners. And just because you're a rich and famous celebrity in the music industry doesn't mean that you can violate the law. So we've carved out a niche practice in doing this, and we're happy to represent these victims. And Soulja Boy, I expect to just be the first of many of these types of defendants that are going to be hit with judgments, and some of them may ultimately be prosecuted as well.
And this might just be the start of a long process in collecting money from him, right? Because I've seen a lot of questions about, well, he doesn't have $4 million. What are you going to do for that? And you talked yesterday about the process, the 10 years that you have to collect on this judgment, and then you can renew that for another 10 years. Are there different things you can do to try to get some money for the plaintiff?
That's the plan. To whether it's to go after his music royalties or garnish any wages that he may have, whatever's getting paid on tour. If he has any real property, we can attach that and sell that. So there's certain things that we can do to enforce the judgment, and we have plenty of time to do so. Now, of course, there may be some post-verdict settlement where he pays a significant sum of money and this gets resolved and it goes away.
Hmm.
That's always a possibility. But, other plaintiffs' lawyers have contacted me in the past 24 hours. Like, wow, this is great, but there's no insurance money here. Why did you take this case? I'm like, well, we took it because it was a righteous case. It's not all about the money, even if at the end of the day, we don't get a dollar out of this. And I expect that we will, and we'll make sure that we go to the ends of the earth to get our client paid. But
Hmm.
even if we don't, that's why you go to law school and you become a lawyer. It's not just about dollars and cents. This is why I was a prosecutor for many years. I absolutely loved it because I like going after the bad guy or girl. And if I get paid, great. But if not, and I
Yeah.
can vindicate my client and she can tell her story and I can dramatically change her life because she's now free from her abuser. You know what? When I put my head on the pillow at night, I know I did the right thing. And frankly, that's why, Meghann, I'm one of the few prosecutors out there that doesn't do any criminal defense work. I don't defend criminals. I don't defend companies. I only represent victims.